Well, Newton's going to contest your definition no matter what it is anyway. So.
Probably.
Here. If somebody's asking a question.
Okay. The question?
Just to make sure.
Sure.
And we need to stand like this for co-presenting?
If you're comfortable with that, go for it.
This won't be a problem at all.
This is surprisingly nice, John.
It is.
Yeah.
It is.
You guys gonna say every other word?
Ideally. My pointer is working. That's good. If Tom were here, I'd be putting this on his face. But yeah, I won't do that to anybody else. Maybe Nagy, if you should.
Which Tom, Bruce or Ryan?
Either.
Because Tim's here.
See the date on it? 1994. He was.
What if I just put this volume down a little?
That is your.
That's the speaker.
That is your device audio. This is all the speaker. 1, 2, 3, 4, 5.
That's it.
1, 2, 3, 4, 5, 6.
Month of vacation.
I don't have many migraine triggers left, but
That's one of them?
Or is that psychotic breakup? One of the.
It would be helpful for us to know before.
So did they get the cable off?
I can eat all of the chocolate covered pretzels. I can eat all of the chocolate covered pretzels. No, I already tried. I'm good. I stopped only out of shame. Not out of discomfort. Discomfort.
Unless you're budget capped.
The discomfort was entirely mental. It was not physical. I don't understand why you're wasting your time with regular impressions when you're chocolate covered. Fill your cup with inferior pretzels. I know. That's what I'm saying. Why would anyone get plain pretzels when there are chocolate covered ones right next to them?
Chocolate covered pretzels are the best.
Actually,
I think I can eat them all.
I like the yogurt covered ones better than these chocolate covered ones.
Which I think actually, as if I were litigating the case, I would say that just acknowledged that they were there. I think that she chose recklessly, in the malice of forethought, to fill her cup with plain pretzels.
Plain pretzels.
I've also recently learned that gluten
That just got reported, Heywood. What? Plain pretzels just got reported.
as to that.
Yeah, that'll be on the greatest hits / outtakes album. Yeah.
Let's hope not.
John tripping over the mic.
Both of the Johns
This
tripping over.
this week is live now.
It is live now.
It is live.
1, 2.
Any question if you're asked?
Got it. Okay.
Get any feedback, just
Slider. Okay. All right.
turn it back on.
Shall we begin?
Yes, let's.
Okay, go.
Good afternoon. I'm John Joergensen, and this is John Heywood, and we're here to talk about legal XML and the legal site MLTC Technical Committee citation formats work.
Exactly.
What are we doing there, John?
I have no idea. Now, we're going to be discussing stuff about citation and law in general. You should understand that though we're talking about the work of the committee, the opinions expressed are, well, ours or mine or not the committee's or OASIS's. So, start off with citation. You know, what is a citation? John, what is a citation?
A citation is a reference to another work.
Exactly.
Let's keep it simple.
Okay, let's keep it simple. Okay, citation. It's a fun concept. Why it's important is that if you want to have access to justice, you have to have access to the law. If you want to have access to the law, you need citations. That's why we're doing this. We're going to take a little trip through the analog print world. This is a Supreme Court case from last year. It's the Obergefell case, slip opinion. On page 9 of that lovely opinion, there's a citation to a case. I just pulled it sort of at random. To Goodridge v. Department of Health, a standard state case. We know from looking at the citation that it's in Massachusetts and that it was in 2003. And because there's nothing attached to the 2003, we know it's the highest court in Massachusetts. That we can tell from just looking at the citation. We've got 2 pointers in the citation. There's a pointer to the official copy of the official reporter definition of the case. I'm having trouble speaking, John. The official reporter, thank you. And the unofficial reporter. Regional, thank you, John. Both of those have a fairly simple system in the analog world. You find the reporter name, you find out where it is on the shelf, you go to the volume number, you pull that volume up, you open it to the page, and the case is there. That's how the analog system works. In the digital world, like for example in Westlaw, this is the same case, the same citation is highlighted in blue. This is what it looks like. Nothing in here tells a computer, tells a parser, for example, where to find the case, other than West's own computer. It's internal database linkage. There's nothing, if you were building a parser to build an automatic citation based on this, you would have trouble unless you had access to West's system. Fast case, same case. There's also, there's a lot of direct database calls, but they also have something, they have embedded into each of their links is an ECF, which I think stands for electronic case file, but I'm not 100% sure of that. It's a very simple parsable string. You're writing a parser, you can find, you could create a direct link to that fairly easily, even if you're not in Fastcase. Google, same case. It's just a link to Google's own internal system. LII system. LII doesn't link directly, but if you're using the Eureka app, Eureka will pull it and parse it, and sure enough, Eureka has. It tells you it's a doc in the Massachusetts Supreme Court Adjudicature Cases, volume 440, page 309. You can get it. They have, in fact, done it. You can go grab the case. You click on the link, you get the case. Fairly simple. It works well enough for most things. This is how, and we get a little diagram of how it works. You've got a case with a citation. There's the citation. You plug it into Google Scholar. It sends you to the case. It sends you a URL, and that's what the URL looks like. You click on it, and you go directly to the case. Let's take a look at a slightly harder use case. This is an old case. This is an 1808 U.S. Supreme Court case, a Marshall opinion called Rose v. Heinley. It's one of the privateering, piracy.
Reporter.
Huh?
Nominative reporter.
It's in a nominative reporter, which was later developed into the U.S. report system. It's a piracy, privateering, admiralty case. Now, in this case, on page 270, he talks about how, you can't really read that, passing from principle to authority, we find that it is in the courts of England we're going to refer to. So he's going to refer to a bunch of English cases. And on this page, there are a bunch of them, including this very first one, which is Flad v. Owen, or the case of Flad Owen. It's in 1 Rob 114. Now that looks like, okay, that's a fairly standard looking citation. We can find that. If you plug that, actually in this particular case, I was reading this on Hein Online's version of US reports. It was linked. When I clicked on their automatic parsers, they have an automatic parser that creates citation links, it took me to Robinson's Louisiana Supreme Court cases from 1841, volume 1, page 114. This is not the case. The problem when you have automatic parsing without a standard. If you go to Google and you plug in 1 Rob 114 just to see what comes up, you get some interesting stuff. You get discographies, a bunch of stuff. You actually get down here, reports of cases argued and decided in the Supreme Court. It's a Google Books link where there is in fact a case. It's just a citation to a case though, at 1 Rob 114, and it's not the same case. It's the, please read the name of it, it's the Hirschstedler case. It's another admiralty case, but it's not the same one. So there's something wrong there. Something's not right. You plug it into Google Scholar, figuring I'll plug it into a corpus of court opinions. You get cites to Roe v. Wade and Atkins v. Virginia and Mapp v. Ohio. It's not on there anywhere. So it's not working. We're going to need human resolution. Well, as a lawyer, I know, and law librarian, I know that what they're talking about here is an Old English case. This is a case from before 1876. It's going to be in the nominatives. It's a nominative reporter, which means it's the reporter's name is the name of the reporter. And it's probably going to be collected in the English reports, because that's what when they created the British reporting system, they took all the old cases in the nominative reporters, conglomerated them together, republished them as the English reports. We did the same thing in the U.S. with the federal cases. After, yeah, Dan, you have a question?
But isn't there an inherent citation that is not being used there, and that's the one that is inherent in the case?
The name. Well, we'll get there, Dan. We'll get there. We'll get to the case. Just a minute. So, I figure I'm in the English, I know it's going to be in the English reports. I'm on Hein. I'll go to the English reports. This is the chart of all the different reporters. I want to see what Rob was as one of the nominatives. There's no Rob. There's an ECROB, which is ecclesiastical cases from 1844. There's a WROB from 1838. And finally, there's CROB, which is Christopher Robinson, 1798 Admiralty cases. This looks good. So we'll go to that particular volume of the English reports. Volume 1 of Christopher Robinson's Admiralty reports and the English reports. We'll go to the appropriate page, which would be 1 CROB 114, which is page 116 in the English reports. Up here it says, 1 CROB, and right here it says 114. So this is where the case should be. Except it's not the case. It's the case we saw on the Google site. It's the Herstedler. It's the wrong case. So what happened? Did Marshall screw up? I mean, did Marshall? I don't think Marshall had clerks in 1808. Right. So something's obviously wrong. We'll go look at. I decided I pulled the actual nominative reporter. Pulled the nominative reporter. This is the English, published in London. Went to page 114. Sure enough, it's the Herstedler. So then I went to in that nominative, I went to the table of cases reported, see if I could find the name. And sure enough, there it is, on page 135. Really odd. There's a note down here which says the references to this edition are the references that are in the table of contents are to the first edition. This is the second edition. So the page numbers are going to be a little off. They're going to be off by 1. So I went looking. Sure enough, here's the page. Here is the actual case. It's the Flatiron. It's page 135 on the way the table of cases in the front of the book did, but it's in page 134 on how it's cited in the English reports. So that's the actual appropriate citation to it in the English reports. Here it is actually in the English reports. You can see it. It's the Flatiron. Okay, so what happened? 1 Rob 114 should have been at 1 C Rob 114. It ended up at 1 C Rob 134. The problem is, John Marshall was not using the English reporter. He was using an American version of the report. Same cases. It looks identical, or very close enough to the English nominative, but not. It's an American nominative. Reprinted in Philadelphia, actually retypeset and reprinted in Philadelphia from a copy they got from A. Strackman, who was a law printer, and sold by James Humphreys on the south side of Market Street in Philadelphia. Marshall didn't have access to the English case law. American lawyers didn't have access to the nominative reporters in England because they were too damned expensive. English reporters were extremely expensive. They're printed on very nice paper. They're leather bound. Their market is fairly small, lawyers in England. U.S. lawyers didn't have access to English case law. That's a problem when your whole legal system is based on English case law. So they did what lots of people do. They wrote the Copyright Act of 1790. Section 5 allows you to pirate anything published by someone who's not an American, published outside of the U.S. And that's what they did. Lots and lots and lots of U.S. early case law is pirated, stolen work under current definitions. So they needed access. And this whole little aside was just to show you that the copyright has shaped citation for a very long time and shaped access to law. And it's still going on today. Should you be able to copyright the law? Okay, this is a famous case. You can't really read it. It's Wheaton v. Peters. It's the case that said, in the very last page of it, the last paragraph of the opinion, that you can't copyright case law. Not allowed. The Supreme Court said there is no copyright in the opinions delivered by this court. Doesn't matter, and judges can't sell it. Nimmer on copyright. The preeminent authority on copyright says it's long been held that you can't claim copyright in state court opinions, federal court opinions, state statutes, or federal statutes. Done, according to Nimmer. We're in the state of Georgia. Let's take a look, shall we, at the copyright page on the official code. The official code of Georgia. No disclaimers. Entire copyright, all rights reserved. Take a look at West's annotated California codes. There's a blurb there, but the main part, it just said as a disclaimer, the main part is copyright 2007. No copyright and all copyrightable, it's just copyright in 2007. They're claiming the whole thing. Half a mile from where we stand, the U.S. District Court in Atlanta, Carl Malmuth is getting sued for publishing the Georgia Code without permission. So a lot of this is fairly important right now for access to law. How does it relate to citation? Uniform system of citation. Copyright 2015 by the Columbia Law Review Association, the Harvard Law Review Association, the University of Pennsylvania Law Review, and the Yale Law Journal. They claim copyright in the Uniform System of Citation, or at least in its, though they originally claimed it in the entire Uniform System of Citation, which is law in most states because it is required by court rule to be used in filings. So it is a requirement of most state laws, most state court systems, and yet they're claiming copyright in it. So a bunch of people decided to create their own version of it, Baby Blue, which they then had to change to the Indigo book because Baby Blue was, according to the trademark lawyers at Harvard, a little too close. They're claiming anything blue related with citation at this point. And the reason why this is important is because if you can't have access to the citation system without their approval, you can't make tools like Zotero and the legal version of Zotero called Joergensen, done by our friend Frank Bennett at the University of Nagoya in Japan, where he got threatened by the Blue Book folks for trying to create a citation thing. So you could basically have your Zotero bibliography and have it kick out Blue Book citations that are actually well Blue Booked. They didn't like that and threatened to cut him, actually did cut him off. He's now using the Indigo book. So that's why copyright is important. Do you have anything to add on that, John? Or am I just babbling?
No, you're doing great.
Okay.
Bring it on.
Well, now we know what you're up there for, John.
Yeah, he's my moral support. So that being said, the copyright stuff we can put aside for now. Let's talk about the standards we're creating. So it's done by OASIS. It's the standards group, international standards group. They gave us the open document text format and legal doc ML. And any others you can think of, John?
And many others.
Many others.
Most of them are not law related, but they have dozens and dozens of XML standards used by a whole range of industries.
Yeah. And it's a fun group. We have a good time. We're also, our standard isn't a standard on its own. We're working with a bunch of other standards. We're working with the United States Legislative Markup Standard that's being put out by Craig Bertani's group, or Bertani's group, excuse me, the ECLI, European Legislation Identifier, the European Case Law Identifier, and of course, a Acronyms, which I can never pronounce correctly. These are all standards that are out there. Now, of course, one of the things when you have a lot of standards is you worry about, creating just another standard. Our standard isn't going to do that, we hope, because instead of trying to create a standard for everybody's use case, we're creating a standard that enables us to grab their standards and merge them. Because if you're trying to make a citation standard for 200 plus different legal systems, all different kinds of legal systems is a really complicated thing, and we wouldn't be able to do. 20 people on a conference call, a bad conference call, bad quality conference call, in different time zones, are not going to be able to do this. You need local control. So we're setting up the basic standard that other people will be able to attach to, and so it will work with other standards groups. Okay, this is what we're trying to do. You have a case, or you have a document, say a Supreme Court opinion that you're encoding. You want to put a citation into it. Create a citation using a reference that conforms to our standard when it exists. That will get passed to a resolver. who understands our standard and who will then take that reference and convert it into a URL or URLs and send it to the end user so that they can get a copy of the case. That's the basic concept here. The core of the new standards is a features list. Name value pairs. Real simple name value pairs. Some of these name value pairs will be hierarchical. Jurisdiction is a hierarchical name value pair. Flagstaff municipal regulations, city Flagstaff municipal regulations are inside of Arizona, which is inside of the United States. So that's a hierarchy that can be expressed. Maryland, a decision in a federal court in Maryland will be in the U.S. system, which is in the federal system, and then the Fourth Circuit, and then Maryland itself. Those are all hierarchies that can be encoded. Other name value pairs will be equivalent languages. The primary one I use as an example. Those four things are all the same thing. It can be FR, it can be FRA, it can be Francais, it can be French. That all works. We describe in the standard these features on 3 different axes. By document type. What features does a court opinion have? Document title, author, jurisdiction. What are the basic things that apply to a court opinion? What features will apply to a statute? What features will apply to a court rule? That's how we're breaking those off. Also, we describe them on jurisdictions. What features are available in the French jurisdiction? I have a listing of those. And, of course, what features are on which FRBR level? And at this point, we have to have the obligatory FRBR slide. The functional requirement for bibliographic records. Yes, we're back in library school. Top level is work. In our case, say a Supreme Court opinion. An opinion by a Supreme Court justice. That's a distinct intellectual creation. That's the work level. The expression level is the content. Is it the slip opinion version? Is it the report? The manifestation captures what format it's in. Is this a PDF? Is this an HTML file? Is this a piece of paper? What is it? Finally, the item captures the location. This HTML file is on what server, at what URL? Those levels, we're going to then describe features. As you'll see later on in the presentation, you'll see how the various features slot into various parts of the FRBR level. We have 2 machine-readable frames of reference, a source frame and an interpretation frame. The source frame is only what you see in the written citation. So you've got a case name, you've got an identifier of some sort, like a volume number and a reporter and a page number and a date. Sometimes you'll have a judge's name, whatever's actually in the citation. The interpretation frame is whatever you can infer from that written citation. You, the creator of the reference, what you can interpret. We'll start with using an example. This is a session law in Maryland from 2012. The source frame for this, what would be available in the source frame would be, well, jurisdiction, we know it's Maryland. We know it's from Maryland laws, we know that's a session law. And there's a hierarchy, an array of document number. The first part is 2012, the second part is 9. And it is a hierarchy because the 9 is under the 12. In this case, for the source frame, 2012 is not a year. 2012 is the beginning of the interpretation frame for this. Well, we know that Maryland is inside the United States, so the jurisdiction actually becomes hierarchical at that point. We know the language is English. We know that the title, because we're the people who are writing the citation, we know the title of this particular session law is the Civil Marriage Protection Act. And we know that the date is 2012. We know a bunch of other things about it too, but there's just not enough room on the slide. Data structures. Standard allows for 3 data structures, 3 types of data structures. Atomic values, strings, numbers, booleans. Unordered name pairs, name value pairs, and an ordered list, arrays. So that's how we describe the standard. We're using JSON, JavaScript object notation, to describe it as we work. This is what it looks like as we work. This is the source frame. As you can see, there's work level, the work FRBR level. Document type is a label for a name value pair. and the value is Maryland laws. Document number is the feature label for an array, which has 2012 and 9 in it. That's how we're expressing the standard as we write it up. Interpretation, you can see it's sort of similar, different levels. In this case, there's a work level and an expression level. We're not really getting much below the expression level in this.
No, and that goes beyond the purpose of the standard in the first
Yeah.
place, once you start getting to that. Because of course, what we really want to do here is, when you're doing a citation, you're describing an object, a document. You're making a reference to it so that somebody can find it. But you need to, what you do beyond identification is extraneous. And so you have to do some amount of description in order to identify a document, but you want it to be minimal. And it has to be minimal because there's only so much information available to you in the first place. What you actually see in an original citation in some sort of text, and what you can reasonably infer from that based upon some set of rules that you apply to it. That's why I'm here.
Yeah. And we've come up with sort of, this is a possible initial limited, possibly fundamental list of features, because the standard isn't close to being done. This is spitballing it. Things that we know are going to have to be in it. Schema. What is what's called the linearization schema? How are you going to take that citation and put it into a string? What is it going to look like? What goes where? That schema. We'll agree on that, on which ones are allowed, and where it goes. Jurisdiction, we know jurisdiction has to be in it. It has to be a hierarchy for the first level is country. So that the resolver, if you have a resolver that understands US case law, and you get one of our citations and it says FR, you know as the resolver you can't handle that, but you know where the French resolver is, and so you send it to the French resolver. Basic idea. Work author, we figure that has to be there. The creation date, at least a year. The language or languages being used, and format for whatever you're doing, whatever you're sending them to, so that somebody knows it's HTML as opposed to a PDF.
The appropriate further description.
Yeah, exactly. Thank you. So this is what the resolving looks like. You take a reference that you have encoded according to the standard. It's either going to be a URI, or it's going to be XML, or it's going to be an RDF triple. One of the three. Most often, I think, probably a URI. Most people are doing so, a reference to something. It gets sent to the resolver. The resolver, understanding our standard, breaks it out into name value pairs. Either storing it for however the resolver wants to do it internally. It's either going to be JSON or XML. They'll then kick that inside the resolver to the mapper function. The mapper function will take that feature list and map it. This is the magic part, the ... profit, question mark profit part. Will kick out a URL or a series of URLs and return them to the user. That's how it will all work. The standard that we're talking about takes place here, in this section, between the reference and the resolver. How do you encode the URI or XML or triple, and how do you decode it into name value pairs so that the resolver has a constant thing to work at?
And interestingly enough, referring back to John's original cartoon about, isn't it, we have all of these standards, wouldn't it be great to have a standard that brings it all together? And what's the answer? We now have 15 instead of 14 standards. Right now, with this area that we're working on, there is no standard at all.
None.
So this would be a standard. And just to be clear what's going on here, what we're talking about is kind of a middleware standard, is a way to think about it and to describe it. Right now we have lots of standards all over the world for things like case law, for cases to refer to each other or for people to refer to cases. They're all human readable. They're not machine readable in any meaningful way. And now again, a human being looking at it can narrow it down to one or two cases they can understand through knowing and inferring what's referred to in the code, like MD is Supreme Court of Maryland, for example, and that the first number is a volume number and the second is a page number within a certain set of books. Those things can be inferred, but you need to make the rules for a computer to, of course, understand the reference. And those rules need to be made very explicit. So that's part of the standard, the rules to make those kinds of things explicit, so that in the end, the standard that we're making can translate from a citation you would see in print to a machine, a general standardized machine interpretable string in JSON or as a URI or as whatever. And with that standard computer interpretable string, that can go to any resolver. And at that point, it's the question of any business that wants to make use of them can start getting into the business of programming resolvers to then get you the document from any place that's got it. And that's profit for anybody who wants to write them. But in order to write those resolvers, you have to have that standard machine-readable string that doesn't exist right now. Everybody's got their own proprietary thing with their own database backends. There needs to be a standard way for everybody to refer to the things that the computers can deal with.
So the end product of our, I guess, the deliverable for the committee is a standard that is a vocabulary of feature labels and how they work with each other, how they behave with each other, a common set of values for the simplest labels, agreement on what FRBR levels those features belong at, and how you group them, what groups where, and what features those where. The reasons why we can only do the simple things are, well, non-Roman characters are a big problem. They're huge. Differences between unitary systems and federal systems, between common law, civil law systems, people do things differently, and the existing schema standards that are out there that we want to work with. So the linearization schema that John was talking about, where you have to bring them all out, is a string composed according to the constraints of a single syntax. I'll show what that means in a minute. We're not going to mandate any particular schema. It's going to be whatever fits with the, you make it work with the standard, and whatever's after your basic, your part of the URI is yours to decide how to work with. What would the URI look like? This is sort of, I took Grant's U.S. legislative markup schema and sort of translate it into what it would look like possibly when we do it. Citation to the U.S. Code, right? 16 U.S.C. 47. LCM, which is, I think, going to be our string that tells you that it's one of our citations. U.S., because it's the U.S. is the jurisdiction level. Then it's under the U.S. We'll say USC is U.S. Code, T is Title 16, S is Section 47. Fairly simple. Public laws would have the same beginning, but instead of USC, it would be PL, which would tell the resolver it's a public law, and to go to the 101st Congress and the 369th law and pull Section 2. Older ones where you have chapters and act dates could be done this way, using a full date enactment and the chapter number, which is the public law number. Or if it's just a simple citation to the stats at large, again, since we would, the folks who are doing the U.S. legislative part schema are the ones who would say, well, after U.S., we can say that stat will define statutes at large. Here's another example from across the pond. This is the European Case Law Identifier. They've done a lot of work. It's just fairly newly released. As you can see down the side here, there's a list of all the member countries' flags. And if you click on each flag, it'll tell you how far they've come. Not very many, I think. Well, the EU itself has joined the Case Law Identifier. They use it. The Patent Association uses it. And there are maybe, I don't countries that have implemented it in the EU. There are another less than a dozen that are thinking about doing it, and there are some who are not going to do it at all at this point. So it's an add-in standard. Their thing is real simple. It starts with ECLI. Everything's broken apart by colons. You have a country code, you have a code of the court that rendered the judgment, the year, and then you get 24 characters, 24 alphanumeric characters to play with. If you're the person in charge of your country's ECLI implementation, to specify a particular opinion, however they want. Here's an example of one. This is a Dutch court. ECLI tells you that it's a European case law. It's European case law. Country code. Everybody's, I think, going to use the standard international country case codes. HR tells you it's the Hoge Raad, which is one of the courts in the Netherlands. Your judgment is 2015, and it's the 472nd published decision. Some countries in Europe are having problems with this because their judgments of their courts aren't sequentially numbered. So they're going to have to deal with how they do that.
Yeah, one of the problems that we're dealing with now, you've seen most of the examples that John has shown you we've been talking about case law, but showing you examples of legislation. The reason for that is
legislation's easy.
Legislation's easy, and our legal XML work with this in the committee is about 2/3, a little more than that done, and now we're starting to really get more and more into cases. And there's problems all over the place. I've got my own ideas on what the solutions are, but one of the problems you can see right here, embedded in what they're showing and what John's saying, is that the Europeans don't think about this the same way we do at all. They're talking about establishing standards and then handing responsibility over to certain organizations within each country, the government, somebody within the government, who will just be able to handle it. And where in America, where in what part of America could you possibly do that? Some courts might actually jump at the chance, but probably not. A metadata standard, they'll blue book and even require variations on the blue book for localities like New Jersey. But they're not going to do a metadata standard for embedded linked data. So these are things that are still under active negotiation. We have to set up a standard in such a way that there doesn't have to be an overseer within the government to make decisions about how it's going to look. At the same time, with things like the ECLI standard is established and it works, and it looks an awful lot like the kinds of directions we were heading in the first place. So what we have to do really needs to be compatible with these things as well.
Yeah, Dan.
To things that aren't addressed by this, that how does it handle iterative process? Over the course of time, the actual document is going to be different. How do you indicate the point in time?
But for citations, that's really a dating issue.
Yeah.
And there's lots and lots of talk that has taken place with legislation, versions of legislation and the dates that have to happen. And the fact that there's probably there are more than one set of dates that has to be part of a fully fledged string to describe a piece of legislation for just the kinds of reasons you're indicating.
And that's going to be, I think, jurisdictionally driven. So we would have it, but perhaps, Belgium might not. So we leave it to the local.
Yeah, and then the big headache is you have to come up with something that's going to have a lot of little holes in it but a lot of places where different people can plug things in where they need to plug it in. And then it's a question of being able to, within your string, to leave enough hints at what you're doing and how you're doing it so that a resolver can pick up on those hints and resolve it appropriately.
Pull up the case law that you can
I think that's beyond our standard.
Yeah, this
Maybe
is,
too complicated.
yeah, I mean, that's one of the things that also is, you know, on the phone calls is a fairly constant thing. You know, mission creep is always happening.
It's hard enough to do the basic part of this.
Yeah, and then people are writing up little examples of resolvers, and then the question is okay, well, can we import this bit of code into the standard? And it's, no, we're not going to import that into the standard, because that's the resolver that's going to be written based on the standard. Keeping it simple, the reference, and that's it, so that other people can use it.
This strikes me as a highly promising and interesting. One thing that occurs to me is that if you don't have it already, it might be useful to have some expressly stated objectives of the overall project. It strikes me that historically one might say that uniform citations had two objectives, maybe the primary one being allowing a researcher to find the original, whatever the thing is, with a relatively minimal level of effort, and maybe secondarily an objective to do it efficiently, and that is when everything was hard printed, you prefer a citation that was, if you could do it, you know, 20 characters rather than 70 or 80,
Right.
and that would result in judgments of giving, at least for standard opinions, the year of publication, but not the exact date. And it strikes me that there are all sorts of trade-offs where traditional citations had multiple reporters, official and non-official. Arguably, one advantage of redundancy was to guard against an error entry in one of the two things, so that you could find it anyway. It strikes me also that you might consider more explicitly audience. Your Maryland citation probably only makes sense if you're assuming that it's oriented to at least primarily a U.S. audience. Because what in principle a foreigner might think, you know, gosh, just with those numbers, 2012 MD, maybe it's an ordinance of the city of Madrid in Spain. If you're not told that you're within
What we're
the
doing
US.
here is we're trying to, the standard is for the person who's encoding the reference. And my assumption is that the person who's encoding say you're going through Supreme Court opinions, that you would know, you would be a local area expert and would know. And if not, you would kick it somewhere else.
Yeah,
Well,
and
but then who's the consumer though is a different issue after it's quoted, isn't it?
Except,
yes.
yeah,
Well, I mean, to be clear on two things, and one, I'm not sure whether this is what you were thinking, but I'll say it anyway in case other people are, is to be sure the kind of standard we're working on is not something that human beings are going to see.
right.
I mean, one of the values behind the standard is to make it human readable, because that makes it easier to work with.
Debug it.
But the string, the kind of URI strings that we're talking about is going to be embedded in a hyperlink. And you're just going to see the old style of citation that you've always seen, a blue book or an Indigo book citation.
Yeah, right.
And that behind it, there'll be a URI string that if you looked at that, you could interpret it and read it. But even more than that, a machine's going to be able to read it and interpret it. Also, to be fair, that like the Maryland string, that was incomplete.
Oh, yeah.
There would have to be preamble material before that to say that it was our kind of citation to begin with, then it was
LCM,
US,
US,
and then it was a statute,
Right,
and then,
exactly.
yeah.
Taking you from
Right.
the greater to
Right.
the more
That
specific.
helps.
Now, the EU has a working resolver up and running if you want to play with it at ejusticeeuropa.eu, ECLI, You just attach the ECLI string to it, and you get something like this, which is, it kicks back a page. This is a page, it's a Dutch case. This page is in English because my browser was in English. And it tells you we don't have this in English. Sorry, it's a Dutch opinion. We haven't translated it. It gives you some information, like you can the issuing court and the state and the dates and the fact that it's a judicial opinion. But you can click on the little language button and switch over to Dutch, and all of a sudden you get all kinds of interesting information about this case. You get a synopsis, all kinds of things in Dutch that I don't understand, and then you get a URL. And it tells you it's HTML, and you click on the URL, copy of the case. It's working now. The ECLI is working now for the 6, 7 countries that are using it. Yeah, Dan.
Are you going down to the work level or just the version level? That is a version level because the work itself is going to exist outside of the language. In the sense that if you translate the case in English, it's still the same case.
Right. Yeah, no, they're doing it just for the official languages.
The standard itself
The standard.
is actually inherently flexible. I'm sorry.
Does their standard have, I'm not totally familiar with ECLI's internal standard stuff, so I'm not sure if they.
Yeah,
if
I'm
they go
not
down
totally
for that one
sure
or not.
about ECLI myself. I think it works along the same way, but I'm not sure, so I can't say. But like if you look at the general FRBR levels, at some point also you have to be flexible with this kind of standard based upon how people are going to be able to use it. So if you have enough information to go all the way down the FRBR chain to actually specify, a manifestation, then that's fantastic. And if you can encode all that, and so the standard needs to be able to go down that far, but not necessarily.
Yeah.
And if you think about how a resolver can and ought to function, a resolver ought to be able to, it ought to be able to give you something based upon enough information, right? So if you've got FRBR information that'll get you to an expression or to be able to just identify a work, basically you should be able to give somebody a document or a choice of documents. Quite frankly, a commercial resolver is going to want to give you their document anyway, right? And so getting to the very top FRBR level is going to be sufficient for most cases, to the extent that you can drill down and be specific, and that's of value to a publisher who is actually putting out documents and using this standard for hyperlinks. Fantastic.
And the ECLI standard, with ECLI, if you can put in, if you don't have the full string, if you know basically everything, you go to the court in the year, and that's about all you know. If you plug that in, it goes to the search engine, and it will pull up a browsable, you can browse to see it until you can find the right case. Sort of what we did with the cases reported in the nominative earlier in the presentation to find the name of the case. Any questions? We're done.
Yeah.
There's no photo creds on that picture.
I know, I didn't have time. I will put it in before I post it.
We still have 10 minutes.
It's her. Photo. Charlotte Snyder, photo credit. There.
Thank
You
you.
can set it even to the microphone. Any other questions while we're here? Anybody got any? I think we put him to sleep,
This
John.
wasn't a picture of me actually on a conference call for Legal XML.
But it could be.
It could very well be. Yeah, come on.
So is the whole idea behind this is gonna be an open access thing? And this is to kind of promote or to support the free law movement or the idea of that?
And other things as well.
Okay.
And
And so
commercial publications.
So I guess my question is, what happens if like West does this, how does, I don't know how to put it, like.
They're free to use our standard anytime they want.
But you want them to, yes. Okay.
Absolutely.
That's my question.
The extent to they do that, it's all great.
Yeah.
Anybody and everybody.
This isn't just open free law. This is
You want everybody.
all publications.
So
all law.
Lex is
Everybody
plus
should use
open
it.
law, plus Google Scholar,
Mhm.
so that way we can, as we get into more machine readable things, yeah,
when this whole idea first got rolling as something that Legal XML and OASIS was going to get involved in, I was approached by several people. I officially convened this technical committee within OASIS, but I was asked to do it by certain representatives of corporations who, interestingly, still do not want to be named. But large corporations that are involved in legal information and legal publishing, who really wanted a standard like this to be established and thought that they would benefit greatly off it, as well as many others as well. So everybody's interested.
Another question? Sure. Any buy-in from the actual jurisdictions that are producing this material, and do you need that, number one, and then number two, for instance, if we're talking about Supreme Court cases, the way they're published, that's all regulated by, there are court rules that say that. So would they want to have their own court rules, and then how does that work with, when you get to the legislative body, they're gonna wanna have a whole different, rule of procedure, and then you even have other kinds of legal documents, like administrative documents, where for each agency, will they want a whole different kind of standard, because this is the information that they're out.
There's two answers to that.
Herding cats?
Yeah, the first is the herding cats answer, is that's when we get to the 15 standards problem, right? The other answer, well, I mean, the other kind of two answers to that. No,
I'm just gonna sit down.
yeah. As I think more things come up. One of the things about that is that this is not the kinds of thing, and this answers your question to a certain extent, but not fully. This is not the kind of thing that these kinds of organizations within the government really care a whole lot about, because the courts care about the citation that you see on a page. And we're talking about something, again, that you're not going to see directly. This is going to be a URI string underlying the code. And to the extent that they are going to be concerned about it, again, herding cats. Number two, we're going to present something easy, easy as possible, reasonable as possible to use. And, that's how standards work. You lay it out there and hope that people use it.
There has been some buy-in on the legislative side. Congress is actually fairly interested in standardizing.
Well, let's also be fair to the people who are doing it right. The U.S. House of Representatives, Office of the Clerk is extremely interested in these kinds of standards. Yeah. I say that because the Senate refuses to get involved in this sort of thing at all.
Until someone dies.
Yeah, and until a certain person who does happen to be a Democrat, I'm sorry to say, but it's true. But there you go. Yeah.
I guess this is probably more of a comment than a question, but I guess the large legal publishers that wish not to be named and don't want to get involved, they might be one of the few people that have enough power to actually make the courts go along, just because they're the quote-unquote official publisher. Just seeing like what in my research, seeing like how state courts adapt, change how they publish law or what they give the publishers as raw data. It might be something. Next time you talk to them,
It would make it would make everybody's life easier.
Yeah, they might have enough juice to actually make the courts do something instead of this one random city.
I think first we need to have a standard.
Yeah.
But couldn't Westlar,
We have to get
whoever you're talking about, just do it with the stuff they get in, automatically put it down on there?
Well, oh God, fine. Say it.
They already do it for their own internal stuff, so.
Yes, absolutely.
Make it a de facto.
Well, there are companies out there who behave in that manner, and their mission in life is to have everybody to just use that service. And that service does work very nicely along those lines already, because they have done their internal methodology for doing just that. This is true. I mean, you can link from outside of some of these legal databases to resources within those legal databases right now by using a fairly well-formatted string. So that's just this kind of thing already in operation, but that's proprietary and it's not easily translatable to other vendors and other material that aren't used on those systems and other jurisdictions that don't work the same way. We need something more generalized and more open.
So conceptually, if they all decide to use the same string.
Right, but this is what I was hemming and hawing about talking about, is when you do this, you democratize, getting back to your original theme, John. You start democratizing the system so that everybody, the commercial players are dealing with each other and the non-commercial players are all dealing with each other on a much more even field. Because we're all starting and dealing with the same base data and then doing whatever we can with it and putting on all the bells and whistles we can with it, with better and better resolvers and more value added. There are many companies that aren't interested in that whatsoever. There are many that are.
Courts really have an incentive to embed links in their citations in their work product,
No.
in their opinions?
There is incentive for nonprofit publishers of such things and many for-profit publishers of such things to embed those strings. I mean, that's one of, well, actually,
I mean, one would think
there
that,
are some courts in some countries, not the United States,
Right.
who do have that.
sure.
But for those that don't, I mean, and that's one of the things that we talk about is, and that's kind of the reason why we talk about it a little bit the way we talk about it. There's the data that's explicitly in a citation that you can rearrange and put into a more machine-friendly string so that it can be machine-read, and then other information that you can interpret and derive from that information that's there. That looking at it as a human, you know it's there, but it's not explicit, but you can write a rule. And so there's going to be development on both sides. We've been talking about resolvers once those strings are there and embedded, but quite frankly, I mean, just from what you've said, there is the other side of the initial business for when you get documents, writing systems that will generate these URIs in the first place.
I mean, one would think
based upon rules that we're writing.
One would think absent a standard, it would be a good argument for a court to make, why should we bother to embed links in our citations at all? Because if we're the state court of California and we have a Lexis contract, we know that the links we use are gonna be Lexis links and, you know, absent a standard. And then that limits the number of people for whom those links are of any use anyway, so why bother, right? So the standard would actually seem to me to be a positive step in getting courts to do more of that kind of thing, because they would know that what they were doing was feeding into a larger system and not just.
Oh, and that may be how things happen, but we'll see. I mean, I started presenting at CALI in 1997, talking about me getting New Jersey court cases online, and this is on the same theme, although it was said in a slightly different way with a very different attitude, is that I was being foolish to do this because this is the job of the courts, not of an academic institution. I didn't say so stop it, but it was, there was a sneer, there was a definite sneer going on at the time. But yeah, I mean, relying on the courts for anything is a bad idea. And it's been talked about forever, and it doesn't seem to go away for some reason. And to my mind, and this is always the way I've thought about it, is that it's kind of crazy to think about the courts as the drivers of this sort of development, because they're in the business of deciding cases, and they are so busy doing that and so overwhelmed with just getting that done that they're always going to resist doing doing anything over and above that, unless you hand it to them on a silver platter, and it's going to take a while before them to realize that, number one, you are handing it to them on a silver platter, and number two, that it'll make their lives easier. So it'll happen, it could happen, but, you know.
Thank you all.
Thank you all.
John, did Tom tell you about the thing we built? The resolver we built? Sorry, I meant that John, but you're John. Did he tell you that when he visited? I know he was just down there. So Peter Martin built this thing, and he gave it to us as a present. And it's the flip side of what you're talking about, which is you can, and it works. I've seen it work. I mean, it worked when Peter handed it to us. We're still fiddling with it because that's what we do.
You broke it, right?
Probably. But you put the citation in, and it shits out a list of links from every service to that case. So, because there are courts now that are requiring hyperlinks in e-files. So if you're a Lexis guy in the federal court, wherever, is saying you have to have hyperlinks in your citations, and those have to be Westlaw links because we're a federal court and it's Westlaw.
You know, I've done that for years.
Yeah, it's not hard.
No, but it's, you know, it's an easy little database function that you do
It's a pretty
it.
easy piece of code.
When I started hyperlinking all of the New Jersey cases, it was a simple thing.
It is.
You know,
No, it's been a nice day, so.
we're
Yeah. All right.
based on docket numbers. So you take a citation, translate it into the docket number using a database, and then give the person the document. And if the database lookup fails, then you give them a link to Lexis and Westlaw.
Yes. So we're supposed to be debuting this thing shortly.
What's the name of that thing? It sounds familiar.
Well, Peter was calling it Law Fetcher and asking us to
That's-
change the name.
Yes.
We're naming it after Tim's dog. We're calling it Rio now.
Ah, that's a good thing.
For read it online.
Yeah.
So if you give 31 US 551, whatever that is, it'll be like, here's that case in West, here's that case in Lexis, here's that case in Fast Case, here's that
He
case in
does that
Rabble.
on the European side. Justice does that. Justice has a thing called Just Cite in the UK. You type it in and it gives you all the different free sites, anything, any way you can find it.
Well, the funny thing is Rabble is really anxious to have their API and their URLs play very nicely with this thing. And Sarah's like, we should humor them because they're going to figure out how easy it is just to make So we should take their calls and we should,
Absolutely.
So hopefully we'll get some.
You did. I think so.
But
Well, at least Heywood earned it for you.
I couldn't have done
Again, you were nice as the affirmation.
Yeah.
You're doing fine.
It's always better to, I enjoy
He's
doing
good at that.
presentations with somebody
He does
else.
that when he actually.
Because you can do a back and forth kind of, much easier.
This is your thing today, huh, John? You have a rattle next to Dr. Reed today?
50% of the time, give or take.
But I think it's interesting that courts are now requiring litigants to provide hyperlinks.
Are they now?
That's what I'm saying. That's why Peter started this, because he was noticing this trend in local rules with e-filing, because that's Peter Martin's.
Right, yeah.
Open citation, and that's the world, that's the lens he sees everything through. So
Which
he
is a
was
good lens
seeing,
to
he's
take
got
it.
lists, right? He was seeing courts start to do this, saying, you're e-filing, you have to give us, and some of it's permissive. If you want to put hyperlinks in, but I feel like there are a couple of courts now where your e-filing has to, your case law has to be hyperlinked. And what do you do? If they say it has to be Westlaw, and you're a fast case guy through your state bar subscription.
Right.
What do you go to the library once a week? Every time you got a brief due, you go to the local law library.
You can't get
Look up
Westlaw
19
for that.
cases. Well, I mean, that's my experience at Cornell. Is that I can go downstairs.
Well, your academics, we have to go there because we're members of the general public. If you're a lawyer down for a firm, and you have fast case, that's what you do.
Or
Yeah.
so it's.
I like fast case a lot, actually.
I haven't had a chance to put it there. I like Ed. Awful.
It's it is what it is. It's fast. I mean, it pulls stuff up fast. And I like the visualization tool. That's helped me a couple times. It's sort of my go-to now. Wes is just pissing me off.
Like everybody else, though, I, as a practicing lawyer, rely so heavily on the secondary materials in this.
Yeah. Yeah.
That's what, other than,
I know.
I was explaining to somebody the other day that I was surprised wasn't aware of this. I was like, that's not really, it's not really West's business model to make money on primary law.
Hey, Matt, there's a from this
It's not even
Do you know anything about that?
treatises, but it's also, they're diversifying into all sorts of knowledge management, practice management, building systems, website design, because they know. People at this conference have taken the value out of, oh, you want the US code? That'll be $4, you know? It just doesn't happen. You can't make money on it.
Would you say?
It's all good. Tim's gonna take him down eventually.
I'm surprised there are actually people here. It's always surprising. I'm not surprised that there are people here paying. I'll keep that in mind.
Yeah.
To citation.
No, that was really interesting. I'm eventually going to steal your example of how long copyright is.
Yeah, I wasn't gonna do that at all, so I'll just leave that in the standard. But I wanted to work in Indigo. But I was doing some research on the case that long US reformer. Okay. An article on it.
I think you have, and it's just giving me anxiety.
Political approval.
So that was actually a thing that you came across when you were doing research? It kind of felt like a hand-picked example, but it was so, like, how would you find that example then?
Yeah, for 2 years, I had nothing to write about. Basically, we started attacking our predators from Baltimore.
I'm letting it go, but it always creeps into the back of my mind, like I'm behind.
And so they set themselves up. About at the same time, all of Spain's possessions in this world started revolting. So they signed themselves up here. Privateers for them, and then got caught. And it's
You all
those
changed the
cases
war.
that came out of it, and how Marshall was just on the secretary of state.
What happened to that? This one is messed up. It's fascinating.
Yeah, it really is.
I can't believe it's
You gotta love a name like Flat.
It's still not working.
And that last.
Here, where's the other end?
I no longer have trees around.
It'll happen, and you'll find it out, and get over it. That you just brought in.
Vacation.
There would be, tenured academic.
Here, let me get that. Let me get that.
Okay, well, there's one secret handshake, I'll tell you right now.
Yeah, there are RDF Python libraries, they're not as well developed as something like CALIcon16.
Okay.
Okay, I got that. Are you sticking around for this one?
No, it works.
This one is Harvard's.
Just tight.